All right, buckle up for this one, because we're diving into a Supreme Court case that's, well, it's a big deal.
Yeah, this one's got it all.
We're talking fishermen, legal battles, and a ruling that could change how the government operates.
No kidding. It's Loper Enterprises v. Raimondo, and let me tell you, it's a wild ride.
So what's the story? Give us the rundown.
Picture this. You're an Atlantic herring fisherman just trying to make a living out on the open water.
Okay, I'm with you.
The National Marine Fisheries Service, or NMFS for short, comes along and says, hey, you need to pay for an observer to be on your boat.
An observer? What for?
Basically, to watch you fish. Make sure you're sticking to those catch limits, to prevent overfishing.
Sounds reasonable enough. Keeps things sustainable.
Right, good in theory. But here's the catch.
Uh-oh, I bet there's a catch.
These observers, they aren't free. We're talking potentially $710 a day.
Whoa, $710?
Yeah.
That's a hefty chunk of change just to have someone watch you work.
Exactly. And that's where our main players come in, Loper Enterprises. They're a fishing business. And that daily fee, well, it was eating into their profits big time.
So I'm guessing they weren't too thrilled about this new rule.
You could say that. They decided to fight back, and their argument was pretty interesting.
So did they try to say catch limits were unnecessary?
Nope, they went a different route. They zeroed in on the National Marine Fisheries Services Authority.
Okay, so they're questioning if the NMFS even had the power to make them pay for these observers in the first place.
Yeah.
Gutsy move.
Exactly. Their argument hinged on the Magnuson-Stevens Act. That's the law that governs fishing in U.S. waters. And they said, look, the act doesn't explicitly give you, the NMFS, the right to impose these observer fees.
So it's a classic battle of you're overstepping your bounds.
Exactly. But what seems like a straightforward dispute about fishing fees? Well, it opens up a Pandora's box of legal questions.
Ooh, I love a good Pandora's box. What kind of legal questions are we talking about?
Well, it gets to the heart of how much power federal agencies actually have when it comes to interpreting and enforcing the laws that Congress makes.
Okay, so we're not just talking about herring anymore.
Not even close.
This case is about something much bigger.
That's right.
We're talking about the balance of power between everyday citizens, the government, and, well, everyone in between.
That's what makes this case so important.
And at the heart of this whole power struggle is something called Chevron deference.
Ah, yes, Chevron.
It sounds pretty technical, like something you'd only hear in a law school lecture hall.
It does have a certain ring to it, doesn't it? But believe it or not, Chevron deference has played a huge role in shaping how the U.S. government has functioned for decades.
Really? Okay, so for those of us who aren't legal experts, what exactly is Chevron deference?
Well, in the simplest terms, it means that when a law passed by Congress isn't crystal clear and a federal agency, like, say, the EPA or the FDA, has to interpret that law to enforce it, the courts have historically given a lot of leeway to the agency's interpretation.
So it's like saying, hey, you're the experts on this particular topic. We'll trust you to figure out the specifics.
Precisely.
And this whole idea of Chevron deference, it stems from an actual court case.
It does. It all goes back to a 1984 Supreme Court case, Chevron v. Natural Resources Defense Council, which is where the name comes from.
1984, that's quite a while ago.
Yeah.
So for 40 years, this principle has been like the guiding light for how courts deal with these kinds of agency interpretations.
You could say that. It's been a cornerstone of administrative law, impacting everything from environmental regulations to financial rules.
Wow. Okay, so back to our fishermen. Did the Supreme Court just say, well, Chevron deference, NMFS wins, case closed?
That's where things take a turn. And this is the really big deal.
Okay, what happened?
The court did not simply rule on whether or not the NMFS had the authority in this specific case. Instead, they used this case, Loper as an opportunity to completely overturn Chevron deference.
Whoa, hold on. They overturned it entirely. They just tossed out 40 years of established legal precedent.
They did. And that sent shockwaves through the legal world because it was completely unexpected. No one saw this coming.
Wow, that's huge. So instead of just settling the fishing fee dispute, the court used this case to, what, rewrite the rules of the game entirely?
Precisely. And to really understand why they did that, we need to dig into their reasoning a bit.
Okay, let's hear it. What was their justification for making such a drastic move?
The majority opinion, which was written by Chief Justice Roberts, argued that this whole idea of Chevron deference was actually incompatible with another very important law, the Administrative Procedure Act, often shortened to the APA.
Okay, two legal acronyms in one case. We're really getting into the weeds here. But what's so important about this APA? What's the conflict?
So the Administrative Procedure Act, it essentially lays out the ground rules for how federal agencies operate, and importantly, how courts are allowed to review the actions those agencies take.
Okay, so it's about oversight, checks and balances, right?
Exactly. And a key part of the APA, at least according to the court, states very clearly that the courts, not agencies, are the ones who have the ultimate authority to decide all relevant questions of law.
So the Supreme Court was basically saying, hey, interpreting the law, that's our job, not yours.
Right. The majority argued that Chevron deference, by forcing courts to defer to an agency's interpretation of a law, even when it might be ambiguous, actually kept the courts from doing their constitutional duty.
Interesting. So it's a separation of powers issue, a turf war almost.
In a way, yes. And this decision has ignited a huge debate in the legal world about which branch of government should have the final say when it comes to interpreting the law, especially when the law itself is a bit hazy.
That makes a lot of sense. And this isn't just some abstract legal argument. The implications of this case of overturning Chevron, they're massive. I mean, if agencies no longer have the same freedom to interpret laws, what does that mean for all sorts of regulations? We're talking about things that impact our daily lives, environmental regulations, financial rules, you name it.
Absolutely. This case has the potential to cause a seismic shift in how the U.S. government operates, and we're just beginning to see those ripples.
So it's a pretty big deal, to say the least. But this wasn't a unanimous decision, right? What did the justices who disagreed with overturning Chevron have to say?
You're right. This decision ended up being pretty controversial, even among the justices themselves. The dissenting justices, led by Justice Kagan, well, they had some strong words. They argued that by overturning Chevron deference, the majority was essentially throwing the whole system into disarray.
Okay, so chaos in the courts.
Yeah.
What were their main concerns? Why did they want to keep Chevron deference in place?
One of Justice Kagan's key points was that Congress, when they write laws, they often do it in a way that's intentionally broad, like they're leaving room for interpretation. And they argued that there's a reason for that. It gives agencies, the experts in their respective fields, the flexibility to apply those laws in a way that makes sense for the specific situation, for the real world.
So they're saying Congress knows that they can't predict every possible scenario when they're writing a law. So they leave some wiggle room for the agencies to figure things out.
Exactly. And they argued that agencies are actually better equipped to be making those judgment calls about the finer points of a law because they've got the experience, the expertise, and they're directly accountable to the president, who's elected by the people, right?
That's a really interesting point. So it's a question of who you trust more to navigate those gray areas, unelected judges or agencies that are at least theoretically answerable to the voters.
Right. It's a debate about accountability, about who has the knowledge and experience to make the best decisions when the law isn't crystal clear.
It's a tough one. So where does this leave us? What happens now that Chevron deference is gone? Should we all be bracing for legal chaos?
Well, it's unlikely that the whole regulatory system will fall apart overnight, but things are going to be different. One pretty safe bet is that we're going to be seeing a lot more lawsuits challenging agency actions. I mean, before, if someone disagreed with how an agency was interpreting a law, they might have been hesitant to sue, knowing that the courts were likely to side with the agency because of Chevron deference.
So Chevron, even if you didn't know what it was called, was probably preventing a ton of lawsuits from ever even being filed.
Exactly. But now, without that kind of built-in advantage for agencies, groups or individuals who don't like how a law is being interpreted are much more likely to take their case to court and see what happens.
So buckle up, lawyers. It's about to get busy. But more seriously, doesn't that mean that the regulatory process could slow down significantly? I mean, if agencies are constantly worried about getting sued, wouldn't that make them more hesitant to take action?
It's a valid concern, and it's something a lot of legal experts are worried about. This could potentially make the whole process of creating and enforcing regulations much slower and more cumbersome.
Which, depending on your perspective, could be a good thing or a bad thing.
Right. Some people would say we need regulations to be carefully considered, maybe even slowed down a bit. Others might argue that we need agencies to be able to act quickly, especially in situations where there's, say, an urgent public health or environmental concern.
It's all about finding that balance, right? Between making sure agencies are following the letter of the law and giving them the flexibility to do their jobs effectively.
Exactly. And this case has really thrown a wrench into that balance. It's going to be fascinating to see how Congress reacts to this.
So what are their options? Could they just pass a new law that essentially says Chevron deference is back in session? Or is it more complicated than that?
Legally, they could definitely try. Congress has the power to pass new laws, and they
Yeah.
could try to reinstate Chevron deference, either as a broad principle or even just for specific policy areas. But whether they'll be able to get that done is a whole other question. I mean, passing major legislation is no easy feat, especially in today's political climate.
Right. That's a whole other deep dive. So we've talked about the courts. We've talked about Congress. What about our fishermen? What ended up happening to them?
That's the ironic part. The Supreme Court, they didn't actually end up deciding whether or not the NMFS actually had the authority to require those observer fees in the first place.
What? So after all of this, the original question is still unanswered.
Yep. They sent the case back down to the lower courts and told them to reconsider it based on this new precedent now that Chevron deference is off the table.
Wow. Talk about a cliffhanger. This is like a legal drama that just won't quit.
Like,
But honestly, this case, even though it started with a pretty niche issue about fishing regulations, it's about so much more than that. It highlights just how much power the Supreme Court has to reshape the legal landscape, sometimes in ways that nobody sees coming. Absolutely. And as much as I love a good legal drama, the real takeaway here is that these cases, they aren't just abstract legal battles. They have very real consequences. This case could impact everything from how environmental regulations are enforced to how workers' rights are protected. It's a reminder that the law, even when it's complicated and sometimes even a little bit boring, it really does matter.
couldn't have said it better myself.
Well, on that note, I think I need a break from all this legal talk. Maybe a nice walk by the water, perhaps with some fresh-caught, sustainably sourced herring.
Sounds like a plan.
Thanks for joining us on this deep dive, and for everyone listening, keep those legal questions coming. Until next time.
See you next time.